Good evening, Prof. So how high is the bar for recusal? And have you seen signs today in Zuma's submission that Zondo actually really should be considering it?
No. The bar is very high. We get our case law on recusal from the recusal of judges, and our leading South African case is from the Constitutional Court in President of South Africa versus Safi, and that made two main points. The first is that the test is objective, which means that it doesn't matter what former President Zuma himself feels. It matters whether an objective outsider would, on the correct facts, think that there's a reasonable apprehension that Judge Zondo would not keep an open mind. So that's the test. And that case also emphasized that judicial officers are actually trained to work out what the facts are and to sift fact from fiction. So, and they have a background that we must assume that there's a level of integrity unless it's proven otherwise. So the bar is high. There's nothing I've seen in the affidavit that Jacob Zuma has submitted that would suggest he'd have to recuse himself.
All right, let's deal with that first issue, the issue of objectivity and this lovely phrase, reasonable apprehension of bias. What exactly does that mean? And is it different from saying you're biased?
Yes, it is different. First of all, the question isn't whether Judge Zondo is in fact biased. The question is whether an outsider would reasonably think he is biased. So, for example, had he started expostulating at some point in the evidence and saying, gosh, we must get rid of this man, or isn't this terrible, it might be that he's not biased and just having a bad day and still has an open mind, but anybody from outside watching that would have a reasonable apprehension. But the word reasonable in law, it simply means that the test has to be applied and explained with reference to some outside factors and outside perceptions rather than the subjective understanding of the particular people in the case.
And then the second issue is that judges are trained to look at, to self-examine, you know.
Yes.
So first of all, the judge themselves must ask themselves, have I been biased? I'm just wondering, is this something they learn at law school? How do they do this? Because it's so very hard to examine our own bias. There must be special training. How does it work?
I can't speak for all law schools. I know that my own law school, University of Cape Town Law Faculty, puts in ethics into the various subjects that it teaches. But I think it's also a matter of practice over the years, both for advocates, you know, practicing lawyers, and for the judges themselves. They learn not to make statements about matters that they may have to decide. They learn to not make a decision on an issue until they can explain why the evidence supports the conclusion they've reached. What Jacob Zuma is complaining about in these affidavits is Judge Zondo's attempt to clarify what witnesses are in fact saying. So he's saying to them, so if I'm reading you correctly, you're making the statement that President Zuma interfered by doing this or by doing that.
Yeah.
Now that Jacob Zuma is taking as proof of bias, it isn't proof of bias. It's proof of trying to work out what the evidence is.
Yes, which is what Zondo is saying. And also in all those transcripts, Justice Zondo is saying it seems on the face of it that what you're saying is this. So that is a really very debatable one. I wanted to get your input, though, on the clip we've just played of Muzi Sikakani. He's basically saying, if Justice Zondo doesn't recuse himself, they can either take it on review or simply he'll instruct his client not to answer questions, which we saw the other week. Doesn't that suggest that actually this is dead in the water anyway, in terms of getting any information out of the former president?
No, it's not dead in the water. It's just being made as tough as Jacob Zuma can possibly make it. First of all, if they put in an application for review, depending on which which avenue they use, I think that the review can be fairly swiftly handled. If Jacob Zuma does his usual Stalingrad strategy, we're looking at High Court, Supreme Court of Appeal, and Constitutional Court, so it is a delay. On the other case, he doesn't have a case for recusal, certainly not in what I've seen so far. And you'd think his affidavit would include some evidence that's actually usable. So it will take a while, but eventually he'll be turned down. Secondly, Sekikani's claim that he can tell Jacob Zuma just not to answer questions is wrong on the law. And much as Dudu Myeni was allowed to get away with it, there's no reason why Jacob Zuma has to be allowed to get away with it, because his evidence is so central. There are 34 witnesses who have directly implicated him. So the commission has to hear what he has to say in response. And there is no right for him not to answer any questions. The way his right against self-incrimination is protected is that what he says in that commission cannot be used as evidence against him in a criminal court. But he cannot refuse to answer a question. And in this regard, the commissioner actually has the powers of a judge in a court of law. And that includes arresting the person who refuses to answer the question and holding the person for up to 3 months and then bringing them back and saying, right, now will you talk? So if Judge Zondo wanted to, he could get really nasty. And I think so far he has handled Jacob Zuma with kid gloves.
Thank you so much for your views. That was Kathy Powell, Associate Professor in Public Law at the University of Cape Town.